All right, everybody, welcome to today's Lunch and Learn. I am really excited to be on this Zoom with folks that I sent a lot of emails to, which is Steve Berlin and Rich Superfine, who are at the City of Chicago Board of Ethics. I'll give a little bit of their bio in a second. For those of you who are attorneys, and I think I have all the permissions correct, this is the link to add your ARDC number. We're also going to put that in a few times throughout. And I also, I've got staff on today. I know our chief of staff, Chelsea Biggs, is going to be helping with some of this. And I do want to point out our city programs director, Ayana Simba, who does most of IEC's city lobbying. So for those of you on our City of Chicago advocacy list, Ayana is definitely a person to talk to. Although I know Steve and Rich respond to all of the emails, but if there's ways that we can connect you with things that we've already done to make sure that we're in good compliance, we're happy to give you those examples. So without that, I wanna get started, and I'll let our presenters give a little bit of intro as well. But I've got Steve Berlin was appointed as the executive director of the Board of Ethics by then Mayor Richard Daley and confirmed by the City Council in December of 2008. Before this appointment, he served as the board's acting executive director from October 2006 and began his city career as the board's deputy director. So he has a long history with this. He has his JD from Northwestern University. And I'll let him introduce his background a little more when I put the PowerPoint on. And then we also have Rich Superfine, who is from University of Illinois Law School. And he is the legal counsel for the City of Chicago Board of Ethics. He's been legal counsel since July of 2004. And very excited to have Rich and also Steve present to us today. So I'll let them add a little bit here. And for folks, let me look at Rich and see for this too. I'll have folks put questions in the chat and then we can answer them afterward.
Sure.
That's okay? Great. And
Sure.
I will, and Chelsea has put, if you're looking for CLE, the link is in there. We'll also end this with it. Make sure you're putting the correct time and we'll follow up with your certificate as well as the PowerPoint slides that we are sharing today. We will be sharing with everybody. So and then let me put the slides up and you guys just tell me when to go to the next one. That looks good.
Fine. Well, this is just the introductory slide, obviously. We can move to, that just gives our contact information. Just by way of introduction, the board has been around in one form or other, actually since 1986 when Harold Washington was the mayor. And there was an executive order board, but that expired. There was a sunset provision and it expired in February of 87. And the city council, it's amazing to me still after all these years, the city council and the mayor worked out a governmental ethics ordinance, even during council wars. And that ordinance took effect in 1987 when our board was officially constituted as a full-fledged city agency. So we're small. We have right now only 7 staffers. We actually have a vacancy right now, not an attorney vacancy, but 4 of us are attorneys, and we have 3 support staff. Probably from your standpoint as either registered lobbyists or potential registered lobbyists, aside from our legal staff, your main person to contact is going to be Delina Bailey, and you can reach her either through email or by telephone. She is now handling all of our lobbyist registration and activity report filings, etc. Some of you may remember Jeff Johnson, who was with us for more than 20 years. Jeff retired at the end of last year, and he's living with his husband happily down in Texas. So anyway, you can move to the next slide, Jen. The ethics ordinance, by the way, has been amended not more than any other provision in the city's municipal code, but it's pretty darn close. It's been amended 35 times since it was first enacted in 1987. And the most recent set of amendments are the ones that we'll focus on today, which take effect on July the 1st of this year with respect to not-for-profit lobbying. I will tell you that when I first started with the board as the deputy in September of 1993, we had about 320 registered lobbyists. And in those days, we actually had entity registration. So we had quite a few more individuals that were lobbying than were just registered, because we allowed law firms, for example, like Mayer Brown or Sidley and Austin or Kirkland and Ellis, we allowed them to register as a firm, but then they would disclose, their 15 or 16 or 25 attorneys that would engage in lobbying. That all changed in 2005. And now we have only individual registration, not entity registration. And unlike the state of Illinois and unlike some other jurisdictions, we do not have client registration. So clients of lobbyists, unless they have people that engage in lobbying, those individuals would have to register. But clients, by hiring a lobbyist, that does not trigger any registration requirements with the city of Chicago. We have 4 basic responsibilities. The first responsibility is ethics training, and I want to thank the Illinois Environmental Council and Jen and your whole team for putting this together and for getting those coveted ethics credits. As I said to Jen before, normally when we do CLE, we get only regular regular credits, but ethics credits are very special. So thank you. So our basic responsibility for all of the regulated communities, such as lobbyists, aside from ethics training, is to help you comply with the law and to issue confidential binding advisory opinions if you ever have a question like, is this particular activity lobbying? Or how do I report this expenditure? Or how do I report this gift? You can call us or email us at any time. We pride ourselves in turning around questions as fast as possible. Normally, we'll be able to get you an answer. Typically, our response time is under 45 minutes. Sometimes it takes a few days. On rare occasion, and it doesn't happen that much with respect to lobbying, but on rare occasion, we do have to bring a question to the entire board. All of our advisory opinions are confidential by law. In other words, if we issue you an opinion, whether it's on the telephone or it's an email, or it's actually a formal opinion that our chair, Bill Conlon, signs, or that I sign as the executive director, it stays confidential. We don't confirm or deny that we ever issued that opinion to you, to the press, or to the mayor's office, or to the inspector general, or whatever. It's your opinion. You can do with it what you please. You can make it public, but we don't comment on it unless we have a specific waiver of confidentiality from you. The other thing about our advisory opinions is that, in addition to the fact that they're binding, is that you can rely on them in the event that somebody files a complaint. Hey, so-and-so engaged in unregistered lobbying, and if we've already given you advice that the particular activity that you asked about did not constitute lobbying, you're protected as long as you gave us the relevant facts and as long as you followed our advice. There's only one exception to this, and that is a rare exception. And it does happen on some occasions. It maybe happens once or twice every other year, so maybe about once a year. Somebody will call us and present facts to us that indicate to our legal staff, the 4 of us, that there appears to have been a past violation of the ethics ordinance. If that's the case, then we'll bring it to our board. And by the way, our board is composed of up to 7 members of the community that serve without pay. And right now we have 2 vacancies on our board. We're trying to get the mayor to fill those vacancies. Then the board will then decide, was that past conduct a violation? If so, was it a minor or technical violation? And if so, then we send the person a confidential letter of admonition that is kind of a slap on the wrist saying, hey, you committed a minor violation, don't do it again. On the other hand, and this is rare, if the board believes that there was a past violation that was not minor, then we are required to advise the person that they may report themselves to the city's inspector general. And if they don't make that report within 2 weeks, then we have to breach confidentiality and make that report. Now, we have advised, Richard, I don't know, maybe 4, 5, 6 people since this law took effect about 12 years ago, that they appear to have engaged in a past violation that wasn't minor. We've never had to report anybody. Once a case is in the hands of the inspector general, we don't get involved. But you can see on one of these bullet points on this page that when the inspector general completes any investigation, if that office believes that there have been 1 or more violations of the ethics ordinance, then they will send it back to us for adjudication. So, and then the board will adjudicate the case. You know, the individual who is under investigation has all the rights to hire an attorney and meet with the board and present whatever arguments they have in their defense or facts they have in their defense. And if the board changes its mind, the case is dismissed, it remains confidential. On the other hand, if the board doesn't change its mind, then we can enter into a settlement agreement with the individual. Those settlement agreements are all made public on our website. And the fines for violations are up to $20,000 for most violations, with one exception, which is if a person engages in lobbying and doesn't get around to registering in the first place, then the fines remain at $1,000 per day. Those are really stiff fines, $1,000 per day, beginning on business day 5 after they first engaged in lobbying. And some of you may remember that back in 2017, when then Mayor Emanuel, he was, as part of a settlement of a lawsuit with the Tribune and the Better Government Association, was required to fork over, and the Tribune then made public about 3,000 emails. He alleged that he was not conducting city business on any email account other than his official account. Well, lo and behold, that turned out not to be true. Anyway, we had to look at all those 3,000 plus emails to see if there were instances of unregistered lobbying. Lo and behold, there were, and a couple of people were fined big time, including Uber and its then lobbyist, David Plouffe, and we fined them together $92,000.
Right.
So that was the biggest case that we've had in this office. Anyway, you know, as far as enforcement goes, and as far as ethics training and issuing binding opinions, please understand that we are here to help. We get no joy out of seeing people get into trouble. If you ever have any question at all, no matter, even if you think it's a silly question, just don't be shy about picking up the phone and calling Richard or me or Lisa or Lauren or any of us in this office, and we will help you. Our goal is to keep people out of trouble, not to get them into trouble. So you can flip to the next slide. So essentially then, those are our basic responsibilities. The fourth basic responsibility is regulation, which is what we're talking about today. Regulation to us, actually you can flip through, I sort of covered this. Keep going, you can keep going. Here we go, you can leave this here. So regulation means to us, it means making disclosures public. So there's two basic types of disclosures that we handle. The first is statements of financial interests that none of you guys as either lobbyists or potential lobbyists would have to file, but about 3,900 city officials and city employees, Richard and I, and all department heads, all elected officials and assistant commissioners, and a lot of appointed officials file the annual statement of financial interest, which is a standard conflict of interest form. We keep those on our website for 7 years. And of course, we review them for not only completeness, but for potential violations. And then lobbyist registration and disclosure. And lobbying has been in the governmental ethics ordinance since it was first enacted in 1987. And you can flip to the next slide, actually. So back in 1987, the definition of lobbying was not exactly the way it is now, but it was pretty close. There were a lot fewer exceptions to what was lobbying. In those days, in 1987, any individual or any organization really, that either was paid more than $1,000 in a calendar year or spent more than $1,000 in a calendar year on lobbying had to register. When Rich Daley became mayor in 1989, about a year later, I'm sorry, it was originally $5,000 under Harold Washington. When Rich Daley came in, he moved that $5,000 threshold down to $1,000, and that's where it remained until Rahm Emanuel became mayor in 2011. When Rahm Emanuel became mayor, that threshold was jettisoned, okay? In other words, anybody who engaged in lobbying, even if they weren't paid, if they engaged in one act of lobbying, they had to register. Now, one other major thing that applies to the not-for-profit community, and I'm guessing that most, if not all of you, are representatives or workforce for an entity that's in the not-for-profit world, is that in the year 2000, when Rich Daley was mayor, there was a scandal that involved the mayor's office and involved a person who since passed away, who had been a registered lobbyist. And the scandal was really unrelated to lobbying. This lobbyist had been alleged to have given a couple of senior aides of Mayor Daley a loan. Okay. Well, what happened as a result of that was that all compensation was removed. In other words, anybody who engaged in lobbying, even if they were not compensated, had to register. But also, equally importantly, was that all not-for-profits were exempt from having to register as lobbyists. And that's why when Rahm Emanuel came in, that was in the year 2000, when Rahm Emanuel came in 2011, he said, we got to close this because there's a lot of lobbying that goes on in the not-for-profit community. So what happened in 2011, which is the way the law stood until Lori Lightfoot became mayor in 2019, was that a compromise was worked out. And like all compromises, it was not perfect. But essentially what it said is if you're an individual who's lobbying on behalf of what we call a one-tier not-for-profit, in other words, a standard not-for-profit that does not have for-profit dues-paying members, you're still exempt from having to register as a lobbyist. But if you are an employee or an officer or director of a not-for-profit that does have dues-paying members, such as the Building Owners and Managers Association, BOMA, IRMA, the Illinois Retail Manufacturers Association, the Illinois Restaurant Association, then those individuals had to register. And that's the way it stood until Mayor Lightfoot became mayor. When Mayor Lightfoot became mayor in 2019, with a relatively new city council, she got the council to pass a law that in a sense revoked that exemption and said anybody who's paid at all, regardless of how much, even if they're from the not-for-profit community, had to register as a lobbyist, even if they engaged in one act of lobbying. Well, not surprisingly, there was a huge outcry from the not-for-profit community, and the board ended up trying to change the law, but then COVID got in the way. But for the past 4 years, the board has only encouraged not-for-profit, people who lobby on behalf of not-for-profits to register. As of July 1st of this year, it will become mandatory if the lobbyist or if the individual reaches or exceeds either of the thresholds that we'll talk about in just a few minutes. So that's kind of a general history of lobbying in Chicago. I've seen it all. It's a very complicated history, but we're hoping that this new law, even though it does impose some administrative burden, we're hoping that this new law will be fair and that it will capture, the transparency that, the public demands. So you can move to the next slide, Jen. So the city regulates lobbying in a number of different ways. The first is, like all entities, lobbyists are subject to the restrictions on gifts. We'll talk about that in just a few minutes. They're pretty simple. You can move on to the next slide. Lobbyists are also limited in political contributions. Probably a lot of you from the not-for-profit community aren't in the business of making political contributions. Just be aware that if you do wish to make a political contribution, first of all, the city's law covers only contributions to sitting elected officials or to candidates for elected city office. So we have nothing to do with contributions that you would make to gubernatorial candidates or candidates for, the Illinois General Assembly. I see that, Representative Williams is here. Has nothing to do with making contributions to candidates for federal office. But if it's a candidate for alderperson, or if it's a candidate for mayor or clerk or treasurer, or if it's a candidate for the CCPSA, the Community Commissions on Public Safety and Accountability, the limit is $1,500 per year per candidate or candidates committee from any single lobbyist. So if any of you were, wanted to, if you were so inclined, you could give up to $1,500 in a calendar year to any of the elected officials of the city, other than the mayor. Why not the mayor? Because you'll see in big red bullet points there in the middle of that slide, since 2011, by executive order, lobbyists are prohibited from making even 1 penny in contributions to the sitting mayor or to the sitting mayor's committee. And the current mayor's committee is the Friends of Brandon Johnson. Now, I will tell you that we had a couple of lobbyists, not from the not-for-profit community, but a couple of lobbyists who did make contributions to Mayor Johnson after he was sworn in. And we have enforcement actions that are going on. So we're still doing legal research. Some of the defenses that have been made challenge the ability of the board to enforce this executive order and also challenge the executive order's validity because it was issued by a prior mayor. So those are legal issues that we have to resolve before we actually resolve those cases. But I'll just say that probably most of you are not in the business of making political contributions, but if you do, just remember, don't contribute anything to the mayor. And if you want to contribute to anybody else, it's $1,500 per candidate or candidates committee per year. You can move to the next slide, Jen. So registration and reporting. So this is, now we'll get into the nub of it all. Essentially, all lobbyists who are registered with the city have to register once a year. The registration deadline was actually last week. It was midnight of January the 22nd. And then they have to file quarterly activity reports. We're not like the state where you have to file more frequent reports. Lobbyists for the city have to register once a year, and then they have to amend their registration if, for example, they add a client or they lose a client or they change their address, that sort of thing. But 4 times a year, they have to file, lobbyists have to file, and all these filings are done on our ELF system, our electronic lobbyist filing system. 4 times a year, you file activity reports, which are not identical to what are filed with the state, but they're somewhat similar. Basically, you have to disclose for each client that you lobbied on behalf of, and probably for most of you, it's just going to be one sole client who will probably be your employer. But we do have professional lobbyists that have up to 40 or 50 clients. For each client, you disclose which departments you lobbied on behalf, lobbied in front of, which actions you lobbied on. If it's a pending ordinance, then you give the ordinance number. If it's a pending contract or a pending rule, you just describe that rule. You have to disclose expenditures that you've made per client. You have to disclose your compensation. And all of that is made public. You also have to disclose your campaign contributions or your political contributions that you made in that previous 3-month period. And those reports are filed 4 times a year. Unlike other jurisdictions, you don't have to name the individual city officials or city employees before whom you lobbied. There are some jurisdictions that require that. The city of Chicago has never required that. And we didn't recommend it when we recommended changes. We know that there are other jurisdictions that do it, but we feel that these reports are already complete enough. So what constitutes lobbying? Here are some of the major changes, okay? First of all, the city does have a relatively broad definition of lobbying. It includes any person or any individual, I should say, who on behalf of another, like a client or an employer, contacts or communicates directly with city officials or employees to influence city administrative or legislative actions. Now, a couple things that are embedded there. Number one, it has to be on behalf of another. So any resident or citizen who's lobbying on behalf of themselves, that's never lobbying. No matter what they're, even if they were doing on behalf of a third party, it would constitute lobbying. That's a person's right to petition the government for grievances. Secondly, we cover in the city of Chicago only the activity that's covered by lobbying is only the direct communication, whether it's by email or telephone or text or Snapchat or whatever, FaceTime with city officials or city employees by letters. In other words, the prep time that you engage in preparation for a meeting with city folks, that prep time is not considered lobbying. There are some jurisdictions that do consider prep time to be lobbying. In the city of Chicago, we don't. It's really only the time that you spend in meetings, whether they're in person or virtual, or the time that you spend writing a letter or composing an email to a city official or a city employee, and then the time that you spend in conversation with those city officials or city employees. So those are a couple of key points. Now, one of the things that we've been working on and that is embedded in the law is a more firm, this was a very strong request from the not-for-profit community in particular, was what does administrative action mean, okay? So administrative action, there are now, or I should say as of July the 1st of 2024, there will be 12 different things that would constitute lobbying. The first is any rule. The Board of Ethics, for example, is a rule-making department, although we've never had any lobbying on our rules. But, for example, people in the transportation industry, the transport industry, the city's Department of Business Affairs and Consumer Protection is a rule-making department. They have lobbyists that engage in backwards and forwards, back and forth whenever they amend their rules. Other departments have rules. The Department of Buildings, for example, rates or fees. A person who is trying to affect water rates, for example, that may fall into your bailiwick. That would be considered lobbying. Bond inducement matters, generally with the Department of Aviation or the city's Committee on Finance or the Department of Finance or the Budget Office. Zoning matters. Guys may get involved in zoning matters to a degree with the Department of Planning and Development. Concession or franchise agreements, essentially that means at the airports. I would imagine probably a lot of you do not get involved in that. Creation of tax increment financing districts, well, you may get involved in some of those with the Department of Planning and Development. Similarly, expression of support for a favorable Cook County property tax classification. Just had a question about that this morning. That constitutes lobbying. The acquisition, lease, or license or disposition by the city of any property. So if an organization wants to buy a parcel of city property and then maybe have it rezoned for a parking lot or something like that, those communications typically are considered lobbying, except the application. The application itself for a zoning variance, that's not considered lobbying. But the meeting with the alderperson, if that's required, or the meeting with the people from the Department of Planning and Development, the zoning examiners, et cetera, if there's a backwards and forwards, that's going to constitute lobbying. The solicitation, or numbers 9 and 10, really are, those are procurement lobbying. The city has not only policy and legislative lobbying, but also procurement lobbying, which again is probably not going to affect most of you in the way that you practice, but it does affect large businesses that are negotiating contracts with the city of Chicago. So it's, trying to get the city to issue an RFP constitutes lobbying. Responding to an RFP or an RFQ, as long as a person does not vary from the standard process, that does not constitute lobbying. And then the last two, 11 and 12, are relatively new, although they codify board case law. If somebody lobbies the mayor, for example, to say, hey, Mr. Mayor, we don't like what's happening in Washington, D.C. We don't like this particular bill that's pending in Springfield. Will you make a call to the governor? Will you make a call to, the House leader and say, city of Chicago either takes a position and here's the position, whatever, in support of or in opposition to a bill? That's considered lobbying by the city official. Of the city official. Why? Because the lobbyist or the person who's asking the city official to intervene or to get involved in a matter that is not a city matter is still asking the city official to act in their official city capacity. And that constitutes an administrative action. So, and legislative action also, the definition really hasn't changed that much and won't change that much, except that it stresses that it means any direct communication with a city employee or official or agency to influence any pending legislation before the Chicago City Council. So that's essentially what it means. So again, you'll see at the bottom here, preparation for meetings with city employees or officials does not constitute lobbying or count toward the activity or compensation expenditure thresholds, although the actual meeting does, or the time that it takes to compose the email or the letter and send that, that's lobbying. But the background into what goes into the letter, if you're a lobbyist or you're a potential lobbyist and you're talking with your executive director or your client or your staff, just about what should go into the letter, not lobbying, but the actual composition of the letter and the following meetings about that letter, lobbying. So you can move to the next slide, Jen. So a couple of important exceptions, a couple of these I've kind of alluded to. The first is one that we see quite often, although not so much with people from the not-for-profit community, but merely submitting an application or corresponding about the status of a city permit or license. In other words, where's my matter in the queue? Okay, that's not lobbying. On the other hand, if somebody picks up the phone and calls the Department of Planning and Development and says, where is my matter in the queue? And Planning and Development says, well, it's currently number 18 out of 25. And then the person says, well, it's very important. We have time deadlines. I'd like it moved up to number 1 or 2 out of 25. That communication is lobbying, because then the person is going beyond just merely asking about the status of something. I mentioned solely responding to a city request for proposals or qualifications. That's not lobbying. Attorneys representing clients in formal adversarial hearings. That's not lobbying. So if it's an attorney who's representing a client before the Zoning Board of Appeals or the Plan Commission, or before maybe the Department of Administrative Hearings, if it's a matter where somebody has been cited for a sanitation code violation, that's not lobbying. And that really has never been considered lobbying. We'll clarify that as of July the 1st, board case law, that seeking services available to all residents of the city, that's not lobbying. Asking for a street closure for a block party, pothole filling, that's not lobbying. Similarly, testifying or commenting publicly before any city agency. If any of you are called to testify before the full city council, or more likely a city council committee, that's not lobbying. Even if you're urging the city council to take a particular action, it does not constitute lobbying. Similarly, and this may well happen because we have a new Department of Environment, which may end up passing rules or passing new laws. If any of you are requested by that department, whose head is Angela Tovar, to help out the department with amendments to the city's municipal code, or help it out with rulemaking, that's not lobbying either. So, and I can foresee some of that happening to you. If it does, and you have any concerns, pick up the phone and give us a call. And then the last one we don't see. Oh yes, at the city's request, I see there's a question from Iana. Yes, it includes alderpersons. Absolutely, it includes any city official or city employee, whoever makes that request of you. Great question. And then last, we haven't seen this yet, but let's say you're attending a meeting and you've got a couple of interns. Maybe you've got some undergrads that are working for you, and all the intern is doing is preparing, helping with the PowerPoint at the presentation. That's not lobbying. You don't have to worry about those folks. So you can move to the next slide. So now the couple of I want to say that these exceptions that I'm about to talk about have been heavily discussed with members of the not-for-profit community, both from the people from the Lightfoot administration, as well as to a degree from the Johnson administration, but mostly Alderman Matt Martin, who heads up the City Council's Committee on Ethics and Government Oversight. Matt and his team deserve a tremendous amount of credit for hammering out these new laws here. As of July 1st, a couple of additional exemptions for persons from a not-for-profit. The first arrow there is that individuals would be from the not-for-profit community would be considered lobbyists only if they meet they have to meet all of these different conditions. First, they're paid, and they have to be paid just like any lobbyist as of July 1st. They'll have to be paid $1,250 or more in a calendar quarter for lobbying. Now, I realize that a lot of you are not paid specifically for lobbying. The only people that we know of that are paid specifically for lobbying are the professional contract lobbyists. But as a de facto matter, if your employer asks you to engage in lobbying, then what you've got to do is you've got to keep careful timesheets. You got to keep records of how long and how much time you've spent on lobbying, because that's going to be critical in determining whether you've met the compensation or expenditure threshold, or any combination thereof. It's $1,250 in a calendar quarter, or you engage in 20 or more hours of lobbying as defined. Then you'd have to register. So number one, you'd have to register if you're paid, and either you are paid more than $1,200 in a calendar quarter, or spend or spend more than $1,200 and $1,250 in a calendar quarter, or you lobby more than 20 hours in a calendar quarter. But you would be exempt if your not-for-profit has an operating budget of less than $5 million or fund balances or net assets of less than $5 million. Another way to put that is all people who work for not-for-profits whose operating budget is less than $5 million or whose net assets or fund balances are less than $5 million are exempt. So that's we've been told by Alderman Martin and his people that exempts about a third of the not-for-profits operating in the city of Chicago, but we still have about 2/3 of the not-for-profits that are larger than that. So, you know, if you're not-for-profit, if you're employed by a not-for-profit that doesn't meet those $5 million thresholds, and both of them have to be met, then you don't have to worry about registering as a lobbyist. Similarly, if you participate at the city's request on a task force or commission or advisory committee, that's not going to constitute lobbying unless you advocate specifically for your own organization to get additional contract or work or grants, et cetera. If you're negotiating with the city for funding a position in coordination, you know, this happens. We have some Bloomberg fellows. We have we don't have them at the Board of Ethics, but I believe the mayor's office has people that are funded by the Bloomberg Foundation. Also, I think they're funded by some of the larger philanthropic organizations, the McCormick Foundations. Negotiating those deals, that's not lobbying. Okay. If you undertake nonpartisan analysis or study or research, and probably a lot of you are familiar with this because it comes directly from the federal lobbying law, and you provide technical advice or you discuss broad social, economic, or similar problems, that's not considered lobbying. Communicating with city personnel to influence administrative actions or legislative actions that solely involve temporary youth employment programs or transitional employment programs, that's not lobbying. That's a specific, that was never in the law, but that's something that was specific, that was put in, I believe, at the request of the Johnson administration. And then if you make a self-defense or grassroots lobbying communication, and these are defined terms. So self-defense communication, which also comes from the federal lobbying laws, means any contact or communication by a not-for-profit or any of its agencies regarding an action that the city is considering taking that would potentially harm, diminish, or eliminate the existence of the not-for-profit or its tax-exempt status. So we haven't seen that yet. We hope we don't ever have to see that. But if you ever are in that kind of a situation where you believe that an action that the city's going to take is effectively going to cause your employer to close its doors, well, that's not lobbying. So, and again, if you ever have questions about, hey, if I send this, would it be a self-defense communication? That's the time to pick up the phone and just call Richard or me or any of the other attorneys in our office, and we'll advise you. And then grassroots lobbying communications are not covered. This was a very long discussion that we had both with the Lightfoot administration as well as with Alderman Martin about grassroots lobbying communication. Some jurisdictions cover grassroots lobbying. City of Chicago does not. What do we mean by a grassroots lobbying communication? It means if you send out letters to members of your organization or citizens saying, you know, write your alderman, you know, write the mayor, write the commissioner of environment, you know, send in a postcard, oppose this, or send in emails, that's not lobbying. So you can move to the next screen. I'm gonna shrink my screen here. So the next screen also is, this has always been the case. We don't cover lobbying of the city sister agencies like the Chicago Public Schools or the CTA. As far as I know, none of them have their own lobbying policies. My understanding is that under state law, anybody who lobbies a unit of local government other than the city of Chicago would, if they have to register at all, would have to register with the Illinois Secretary of State's office. I also am of the belief, although we haven't, since we're not a sister agency, that any of these units of local government could also have their own lobbying rules as long as they're not inconsistent with what the state has. But as far as we're concerned at the city of Chicago, we cover only lobbying of city officials and city employees. If you lobby somebody from the CTA or the Metropolitan Water Reclamation or the CPS, that's not our concern. That does not trigger any lobbying lobbying registration requirements with the city of Chicago, and it doesn't count toward your compensation or hourly thresholds. So you can move to the next slide, Jen. I'm not going to spend much time on this, but do be aware that the city itself has restrictions on its own folks. I, as a department head, when the time comes for me to retire, whenever that may be, I'll be barred for lobbying any city agency for 2 years. Former members of city boards and commissions and former Shackman exempt branch employees are prohibited from lobbying their former department or board for 2 years. Former city council members are prohibited from lobbying any city department for 1 year after they leave. So in case we mentioned this only in case your organization is interested in hiring somebody like this. Like if you wanted to hire me, I'd have to say, hey, I can't lobby any city, city agency or city department for 2 years. And then it would be up to you whether you still want my services. So you can move to the next screen. Similarly, a couple of years ago, the city council passed what we call the cross lobbying ban, which prohibits elected officials from any other governmental unit in the state from lobbying the city. Obviously, elected officials, and Representative Williams, I know you're on the Zoom here. If you were performing your job as a state rep, of course, that's not limited, but you could not, for example, lobby the city on behalf of private clients. So that's essentially what this means. And the next slide is going to be just sort of next slide has to do with City Council Rule 8. You can't lobby on the floor of the City Council. So that's the bottom line here. One of the things that you could do under current law is if you did want to engage in lobbying, you couldn't do it on the floor of the City Council, but the ante room is okay. If you wanted to contact an alderperson during a City Council meeting, they would actually have to leave the council chambers, and you could talk to them and engage in lobbying as long as you're not within the council chambers themselves. So it's conceivable that the City Council will strengthen that by including the City Council's ante room. We'll see if that happens. The other thing I'll say is that city officials and city employees, regardless of their title or position, we are all prohibited from lobbying any other unit of government in the city, in the state, on behalf of private clients. But we're allowed to do our jobs as well. So that if I, for example, was part of a busload of people going down to Springfield to lobby the General Assembly on a potential ethics bill, I would be allowed to do that. I just could not lobby either the city or the village of Evanston or Springfield on behalf of a private client. So you can move to the next screen. So as far as what you disclose, both on your registration statement and on your activity reports, it's by client or by employer. In some of your cases, your client is going to be your employer, but in some cases it may not be. Your employer is whoever pays your check, your paycheck, but your lobbying clients might be the same, but they might be different. And our registration forms and our activity reports call for that distinction. So you'd have to identify who your employer is and who your lobbying clients are. In some cases, they will be the same, but in some cases, they won't be the same. So you can move to the next slide, Jen. So we require, and this is not going to be an issue, I would think, for just about all of you, but it is for people in private industry or in the private sector. Just like almost every other lobbying law that I'm aware of, and these laws go back to the Civil War, lobbyists cannot get paid on a contingency fee basis unless they are a bona fide salesperson. So when you register, you're required to give a summary of your agreement to register, to lobby. If it's oral, we need a written summary of your oral agreement. And if it's written, we need the substance of that written agreement. And we're looking for this, and Richard is an expert on this. All we're looking for here is, are you getting paid on a contingency fee basis? That's the sole purpose of this. So, and then 4 times a year, you'll actually report on how much compensation you did receive for lobbying. Now, again, for a lot of you, because you're in-house, what that's going to require is keeping timesheets and then doing a mathematical calculation. In other words, what you'll do is take your annual salary, divide it by 4, and then calculate, in effect, your hourly rate. It's your effective hourly rate, because if you're on salary, you don't really have an hourly rate because you're not billing clients. But you know, it's your hourly rate, and then multiply it by the time that you spent in lobbying. And if it exceeds $12.50 or more in a calendar quarter, then you'll have to register with us, assuming that your employer, if a not-for-profit, has both net assets and fund balances of more than $5 million. So you can move to the next slide. So information about lobbying expenditures, a couple of exceptions that were, or a couple of things I want to point out that were very, very heavily negotiated is that there are some not-for-profits, for example, that might pay people to march in front of City Hall with a sign. Okay, they may pay them, you know, $100 a day or whatever. Those stipends are not considered to be expenditures, and that was very heavily negotiated. So expenditures for our purposes mean if you host a reception, then the cost of that, and lobbying is going to go on at that reception, then the cost of that reception constitutes a lobbying expenditure. You have to itemize certain lobbying expenditures of $50 or more, so that if you're not based in Chicago, but you spend 4 days in Chicago at a hotel, and the purpose of the trip is to lobby the mayor or lobby the city council, well, then that hotel expenditure would be considered a lobbying expenditure. And you're probably familiar with these from Springfield, but if there's ever a question, just pick up the phone, call Richard, call me, call Lisa, call Lauren, and we'll walk you through it. So you can move to the next slide. Re-registration by January 20th. The only reason we include this is because we do get almost every year people who say, well, I assumed that my lobbying registration just transferred over from one calendar year to the next. No, at the end, by January 20th of every year, or as in this year, January 20th fell on a weekend, so we moved it to the midnight of the first city business day after that. You have to either terminate or re-register and pay registration fees. Registration fees, by the way, we waive all fees, registration fees for persons representing 501c3s or 501c4s, which is probably going to be the bulk of you. So you don't have to worry about registration fees. But remember that in January of every year, you can't just let it go. You either have to terminate or re-register. So you can't just, failure to do either constitutes a violation of the ordinance. So you can move to the next slide. I'm not going to spend much time on this. This is just, the mechanics of re-registering. Again, a lot of you have just gone through this. I know that Illinois Environmental Council has about 5 or 6 of you that have just gone through this. You didn't have to worry about paying the fees. Hopefully you found the ELF system relatively easy to work out. It's just that for those people in the for-profit sector, they have to pay their fees before they're considered re-registered. So, and we've had to find people from the for-profit sector for that. You can move to the next slide. Termination or amendment. That's really in the end up to you. If you decide that you're no longer going to, you maybe 2 quarters in a row, you don't meet the thresholds, you didn't lobby for 20 hours and you didn't spend or were paid more than $12.50, you could terminate your registration. Richard and I probably wouldn't recommend that because it's just more paperwork. If in the event in the same calendar year, you then exceed the thresholds, then you'd have to re-register. The easiest thing to do is if you haven't engaged in lobbying in a particular calendar quarter, you just file your activity report saying that you didn't engage in any lobbying. You still have to file the quarterly report. You would just indicate that you didn't engage in any lobbying. That's probably an easier easier route than terminating your lobbyist registration and then later having to re-register. So we would recommend, if that's the case, that you just file your activity reports that say no lobbying activity occurred in this particular calendar quarter. So you can move on to the next slide. I'm not going to spend too much time on penalties, just to remind you that for persons who are late on any filing, if they're already registered, if they're late on a activity report or on a registration, the fines will be $250 per day, and they will be capped at $20,000, which are the fines for other types of violations of the ordinance. But that's for failure to re-register or failure to file activity reports on time. If a person engages in unregistered lobbying activity and they aren't yet registered as a lobbyist, then those draconian $1,000 per day fines, then those apply, and those add up really fast. So, and these are reforms that will take place on July the 1st. So then you can move to the next slide. Client fines, this is probably not going to, this is not going to apply to you guys, but we have gone after businesses in the private sector that have hired lobbyists that have failed to register, and we can go after them and fine them between $500 and $20,000 per violation. So you can move to the next slide. And then other penalties would be, we've never seen this happen, but the city could cancel a contract that was entered into because of unregistered lobbying, and again, we've never seen this happen. We've never seen this happen either. But if it's not a contract, but a regulatory decision, then theoretically, or actually by law, that regulatory decision is invalid and without any force or effect whatsoever. Thankfully, we've never seen that. So I think there probably are going to be questions, and I know we're getting short a little on time, but you can move to the next slide. I'm not going to spend too much time on the gift restrictions and the campaign finance restrictions. These next couple of slides kind of cover what I talked about in terms of political contributions. Just remember, as far as gifts go, that a lobbying expenditure is not a gift. So if you want to take out a city official or a city employee for lunch, I don't recommend that you do that, but the lunch is for the purpose of lobbying. That's not a gift. That's actually just a lobbying expenditure. And you'll have to report that as part of your activity report. You don't have to say on, April the 3rd, I had lunch with Steve Berlin. Rather, you'd say, I had lunch with people from the Board of Ethics, and this is how much I spent in total. And then this, as a double check, the city person also has to report to us that they were taken to lunch by XYZ lobbyist. If you do give gifts, then you have to itemize each gift that you give to city officials or city employees. I have a feeling none of you are going to be giving gifts to city officials or city employees, but there is a $50 per year limit on that. But again, remember that lobbying expenditures are not considered gifts. They're considered lobbying expenditures. So anyway, I think the rest of these slides really pertain to the gift restrictions and the campaign contribution restrictions. So I'm not going to spend much time on them. But what I'd like to do now is get back to the questions, because I think there are some really good questions that came up. So let me scroll down here.
Well, and I can, let me ask you, I'll
Sure,
facilitate here and ask some of these questions. And I will sign down these slides, and we are recording. So I'll go first to Peter. Is there a reason that someone has to terminate their registration instead of just having lapsed registration automatically be terminated if a registered lobbyist doesn't renew by January 20th in any year?
Well, it's because the law provides that you can't just be silent. In other words, we have to hear from you. So if you wanted to, in other words, you can't ignore it. And we actually have, unfortunately, have to have gone after lobbyists who didn't either re-register or terminate. So, they're both relatively simple things. You just can't ignore it. In other words, once January 20th rolls around, if you were a registered lobbyist in the previous calendar year, you either have to terminate or re-register. You just can't ignore it.
Okay.
The law provides.
And Peter was asking, why do city officials have to wait 2 years and city council members only 1?
The short answer, it was heavily negotiated. It's politics, baby. And here's another exemption. City council staff, they're not subject to any lobbying, post-employment lobbying restrictions. But the short answer is that was very heavily negotiated back in 2014 when Rahm Emanuel was the mayor.
It's we know who has more political power there. What if people are hired? This is from Brian. What if people are hired and are find they need to start lobbying for a nonprofit mid-year, well after the January 20th registration?
Then you just register at the time. You have to register within 5 days of first engaging in lobbying. So the January 20th is really only for those folks who were registered in the previous year. They have to renew or terminate. But people might start lobbying as late as Thanksgiving, in which case they register around Thanksgiving. They'll have to re-register in a couple of months. But the person has to, any individual has to register once 5 days after they meet the thresholds, or after they become required to register as a lobbyist.
Mhm.
Great question.
Yeah. All right. I know there aren't more, but if people want to, oh, there's more. If people, Ayana, why don't you ask your question? I know Ayana's in frequent communications on
Oh, she
behalf of
is.
IEC to you. So
Yes, you are,
Yeah,
Ayana.
just trying to save an email here. Could you further explain the part where you mentioned if you go to a conference? So what is the scenario if you go to a conference and you happen to see someone from the city and you end up talking and I guess technically lobbying, you then have to take the hotel expenses? And
I see what you're saying.
yeah,
No. If you, let's say you're out at a conference in Los Angeles and there's a city person there, what you would, and you lobby that city person for 20 minutes, that would just be 20 minutes worth of, that would be just 20 minutes worth of lobbying, and you'd have to figure out the corresponding compensation for that. The hotel expenses would be if you actually come to Chicago specifically for the purpose of meeting with city folks. Then if the primary purpose of your trip is lobbying, then you would include your transportation expenses and your lodging expenses. But if lobbying is incidental to the purpose of the trip, so under the situation that you asked, if you're at a conference, whether it's locally or it's out of state, and you happen to see the mayor, or you happen to see Alderman so-and-so, or Angela Tovar, the new head of the Department of Environment, you would just count as lobbying the time that you spent in conversation with that individual. Great questions.
Cool. Yeah, we're getting some other questions here. Appreciate y'all. And definitely remember if you're getting CLE, there's a link that Chelsea's put in here. Trig from had asked, sorry to clarify, if an organization is registering for the first time, they aren't bound by the 120 deadline. If they weren't registered in 2023, it does 120 doesn't apply to them.
Correct. The only minor clarification I make is that organizations don't register, only individuals do. But yes, if a person does not start lobbying until July the 5th, then they register in July.
Great. And this was another a question I had when I submitted and paid my $6 for my certificate of good standing. But do lobbyists need to submit current waiver letters in Illinois certificate of good standing? Like, can we use last year's letter, or do we have to go to the Secretary of State and pay $6 for our new certificate?
Richard?
I don't know if in the ELF system, it requires you to attach a certificate.
Yeah.
It requires you to make some statements there that are current. And that letter you submit to us has to be updated every year. So the letter.
Yeah, like maybe because I know at IEC we're attaching like the letter and the certificate, but maybe we're doing too much. So we've got that. So the letter needs to be updated, but you don't need a new certificate of good standing every year.
Correct.
That is great to know. And if anybody wants our example of how we've applied, we're happy to send. And maybe there's pieces we can send on how we keep records for our members, so or how we will keep records. Mimi had asked if a nonprofit has designated employee A as the registered lobbyist, but employee B needs to speak to city officials about a matter. Does employee B also need to register? So that was the first question. Why don't you take that one first?
if employee B would have to register if and only if employee B exceeds those thresholds. In other words, if employee B is either paid and or spends more than $12.50 in a calendar quarter for lobbying, or engages in 20 hours or more in lobbying. So it just depends on the facts. It's a one-off. If employee B is only accompanying the registered lobbyist for one meeting, it's highly unlikely that they're gonna, unless they're paid $1 gazillion a year, which is not likely either, then it's not likely they're gonna meet the thresholds and they will not likely have to register.
So they asked a similar question: if employee A accompanies employee B to a meeting with city officials and they have a conversation together with the city official, do both employees need to register in a meeting?
If and only if both employees were to meet the thresholds. I mean, it's lobbying, but not all, because of the way the law is going to be worded starting July 1st, not all lobbying requires registration. It's just a matter of if the lobbying compensation and expenditures or the lobbying hours meet the threshold. Which is actually similar to the way New York does it and the way Philadelphia does it, and to a degree the way LA does it. So,
Super interesting. Yeah.
Yeah.
Okay, well, we are at 102. So any last pieces here? And of course, we are just annual lobbying on behalf of a nonprofit with an annual operating budget of less than 5 million does not need to register, correct?
absolutely correct.
Okay.
That's correct.
Great, thank you. And I know we still register because we always want to make sure. No, our budget's
Well,
under that, lightly
it's
under that.
interesting you say that. So has Northwestern Loyola, University of Chicago, and DePaul. They've had registered lobbyists even when they could have been exempt. And of course, we're not going to say no.
Yeah, we always want to make sure we're following the law. Okay.
Yeah.
Yeah, well, I think that's all we had, and I'll record this. And we had provided Stephen Rich's info in the slides. We'll send it out to everybody here. We'll have a recording. And I just want to thank Stephen Rich for being so super helpful and quick. We have a great experience with them. And I also appreciate how you left the Department of Environment on the form, even though it didn't exist for 10 years. Keep hope alive. So now we can click that box. So just thank you so much. We really appreciate working with you, and we appreciate the time you took today to do this educational webinar. So thanks everybody. Thanks for the members that joined us, and we'll keep talking about this. So
Thank you,
thanks
Jill.
everybody.
Thank you.
We cannot take credit for the Johnson administration re-adding the Department of Environment, although we'd love to.
Well, but it was still on the form. You never deleted it.
We were hopeful.
Yeah. So
Thank you so very much for organizing
Yeah.
this. And to everybody out there, please don't be shy about calling us or emailing us.
great.
Thank you,
Great.
Jen.
All right. Thanks everybody.
Thank you.
Bye-bye.
Take care.
Thanks. Bye everybody.
Thank you.
Okay, great. Well, I'll follow up with you guys. I'll stop recording.